Product liability. This is a topic that is usually of interest to students. I think it's because of the practicality of it. We can all relate to the idea of a defective product causing injury. And I think because of the facts. We're going to talk about some cases, quite a few cases. This is a topic that lends itself well to cases, and the facts of these cases are interesting. In some cases tragic, but certainly very interesting. And it's a topic that I could try to cover if I can after we've finished torts and contracts because of the causes of action for product liability, and there are several. Two are torts. One is a contract theory, and then another type is statutory, which we'll talk about. The starting point is the public policy behind product liability. It turns out, and I'll explain more in just a moment, the background of this, but it turns out that at one time, 100 years ago or so, it was difficult to sue a manufacturer or anybody in the chain of production for a defective product, except for the person or company you bought the product from directly. Now, this, as we'll see, led to some very strange public policies. And in a nutshell, it resulted in people in the chain of production, companies, not having much financial incentive to make safe products, which is not good. And what that led to today, the public policy today, and we'll come back to this in a wrap-up of it, is how do we make the companies in the chain of production financially accountable for their fault in making a defective product that hurts somebody? And I should point out that defective products, there's two different issues. One is how can you make a manufacturer, a retailer, and so on repair and replace a defective product when no one's injured? It's just the product's lousy or has a problem. Or how do you make them accountable financially if the defective product ends up hurting somebody physically? Now, the other public policy is how do we spread that risk throughout the system? And the answer is by making the companies liable, they effectively raise the price of the product incrementally and spreads that risk throughout the entire system, as we'll see. Now, to give you some background of how this evolved and why I think a couple of these cases are helpful. This is a 1909 Cadillac, and you can see they're driving on the right side of the road, or right side of the car. And cars in those days, of course, had wooden spokes for wheels. A man named Johnson was driving down the road at a breathtaking speed of something like, it was 20-25 miles an hour. Of course, the roads weren't very good in those days. And one of the wooden spokes broke, caused him to lose control, and he was injured. He wanted to sue. Well, here's how the chain of production looked in terms of who bought from who. Johnson bought the car from a local car dealer, okay? The car dealer was an authorized dealer with Cadillac. The car dealer therefore bought the car from Cadillac. And Cadillac, as it turned out, had purchased the wooden wheels from a company called Schwartz. Schwartz, as it turned out, after investigation, had sold defective wheels to Cadillac. The wood that was used was literally rotten. That was the cause of the accident. Now, where's the fault? If we think of it in terms of fault, as in negligence, it was Schwartz, for sure. Now, Cadillac, though, what's its role in this? Did Cadillac know the wheels were defective? It's possible they didn't, although one would think they could have done quality control and checked to see if the wheels were, the wood was rotten or not. But whether Cadillac knew that the wood was rotten or not, certainly Cadillac was in a good position in terms of power and influence to make sure that there is quality control for the product. What did the car dealer do wrong in terms of fault? Well, it turned out nothing. But the law at that time, throughout the United States, was that you could only sue, in terms of defective product, the company that you had a direct contract with The term for that is privity of contract, which is on the next slide. We're going to talk about that a little bit more. Johnson had privity of contract, was in privity of contract with car dealer. Under contract law, and this is warranty, by the way, under contract warranty law, even 100 years ago, you could sue the person you were in privity with, because after all, they had provided you a defective product. Contract law is not based on fault. It isn't a question of whether the car dealer was at fault or not. The car dealer sold you a defective product. So the way it would work is Johnson would sue the car dealer, and then the car dealer could turn around and sue Cadillac because Cadillac had sold a defective product to car dealer. And the damages would be the money that the car dealer paid to Johnson and so forth. Cadillac sues Schwartz. But there are some practical problems with this. Number one, it's inefficient. Why shouldn't Johnson be able to sue the people who are really at fault here, which is Schwartz for sure, and to some extent, of course, Cadillac? Why does he have to sue the car dealer? Makes no sense. I mean, he can sue him on warranty theory if he wants, but if we're going for negligence, why not just let him sue everybody in the chain of production and try to prove fault? The other practical problem is if the car dealer has to pay money to Johnson because it sold a defective product, if it then turns around to sue Cadillac, guess what happens, especially 100 years ago? Cadillac will simply cancel its dealership, or could. And the threat of that and the difficulty of the dealer suing the manufacturer effectively put the manufacturer in a position of being bulletproof financially. This is not a good model. What is the financial incentive for Cadillac to do quality control? What is the financial incentive for Cadillac and Schwartz to make a safe product? I mean, there may be some in terms of reputation, of course. It was a big problem. But in this case, Johnson lost. The court held that, according to the law at that time, he could not sue, and he tried, by the way, he could not successfully sue Cadillac or Schwartz in tort. Now, here's the privity of contract issue. This is summarized in the law at that time. If you tried to sue somebody in the chain of production that you were not in privity of contract with, the only way you could do that was for negligence, and even then, the product had to be inherently dangerous. And for the most part, the court said that cars are not inherently dangerous. We drive them every day. What is inherently dangerous? What the courts at that time said is stuff like dynamite. I mean, really extraordinarily dangerous things. So, the case was dismissed with respect to Cadillac and Schwartz. A few years later, a man named McPherson was driving a 1915 Buick, and the exact same thing happened. The wooden spokes broke. Defective wood. This was a different state, a different court, jurisdiction, law, and judge, but he tried the same thing. Mr. McPherson sued apparently everybody in the chain of production. The focus of this case is Buick, however, the manufacturer of the car. The difference this time is that we're now in a state that had on the highest court, New York Court of Appeals, a judge by the name of Benjamin Cardozo. I want you to remember his name. I've mentioned him before. He was the judge that wrote the opinion in the Palsgraf versus Long Island Railroad case, the lady that got squished by the scales, and which is, of course, a very famous case, and this case is famous too. It really inspired modern product liability law. Now, it took a while for that law to evolve and become what it's known today. But Judge Cardozo, writing for the New York Court of Appeals, said, look, if Mr. McPherson cannot sue Buick and the component manufacturer for negligence, meaning because he doesn't have privity of contract under the law at that time, he couldn't do that, this creates an impossible situation. It's bad public policy. Where's the financial incentive for the manufacturers? Where is the accountability? And what he held then was that Mr. McPherson should be able to sue everyone in the chain of production for negligence. Now, he has to prove fault, as we'll discuss more, but that's a proof issue. But he can sue the component manufacturers and doesn't have to go just in warranty against his direct seller. This is a milestone in product liability law. Judge Cardozo, by the way, later was on the U.S. Supreme Court. I may have mentioned that, became one of the great U.S. Supreme Court justices. So, this case, as I said, inspired modern product liability law, which took another probably 50, 60 years to really get to where it is now. So today, kind of summarizing what I mentioned earlier, the two main public policy reasons for product liability law is accountability, putting financial accountability to incentivize the manufacturers and so on to make safe products. If we hit them in the pocketbook, maybe that'll get their attention. And they can spread the risk of that, the cost of those cases, onto all their customers in the form of raising prices. Now, this last point, I always have to make a point of noting, unofficially, this is not a legal doctrine, the deep pocket theory. We'll see the deep pocket theory at work in this lecture, but years ago I mentioned the deep pocket theory, and a student in class thought I meant an official legal doctrine. So it's not a legal doctrine, it's a reality of life. Plaintiffs and their lawyers who are getting 1/3 want to sue every company they can, and they want to get the deepest pocket they can for settlement purposes. Now, this is a topic I sometimes cover, sometimes don't. Obviously, I'm covering it this time. I want you to know about this. GARA stands for General Aviation Recovery Act, I think it is, but the key is the GA, General Aviation. General aviation is a term referring to non-commercial, non-military aircraft. In other words, private planes, private pilots, business jets, things like that. And that runs today everything from the single-engine Cessna 150 and equivalents to, as I said, business jets. But most of the time, when we think of general aviation, we think of the smaller planes. Now, I'm kind of partial to Cessna. I worked at Cessna as a young person for a couple of years. And my father worked at Cessna 43 years. And I knew a lot of people growing up who worked at Cessna. Cessna is a very important company. It's interesting, when I go around the world, the only two companies based in Wichita that anybody's ever heard of are Cessna and now today, because of other things, Koch Industries. And so Cessna is very important. At one time, Cessna had something like 60% of the world market share in single engine or piston driven, I should say, general aviation aircraft. The product liability litigation costs were enormous. And so companies like Cessna, Beech, and so forth very often were sued. The reality is, and this is the deep pocket theory, when a plane crashes, very often the people on board have quite a bit of money, which means that the people who survived them have lost a great deal of economic dependency, which means there's likely to be a lawsuit against Cessna. There have been many examples of this. Now, often Cessna would win these cases, but it took years and millions of dollars in litigation costs. And I saw a stat one time, many years ago, that Cessna claimed that about 60%, now think about this, note this, 60% of the cost of a plane, of a piston engine plane, was directly attributable to product liability litigation. And that's pretty extraordinary. What happened is it got so bad that Cessna quit making piston airplanes. Well, okay, now you already have a situation where there's a lot of aging aircraft out there. And of course, they're updated from time to time and so on. And now you have one of the world's leading manufacturers of these planes no longer making new planes, which means the planes get older and older and older. This is not good public policy. But Cessna said, we cannot make a profit making these planes. The cost is getting too much. Cessna also lobbied for a change in the law, saying that if Congress will pass this law called GARA, we will get back in the business of making piston-driven airplanes. Yeah, or piston-engine airplanes. So what is GARA? The statute of limitations to sue for negligence is 2 years. but it's 2 years from the date of the accident, essentially. Well, so a plane made in 1950 that crashed in 2000, that's 50 years later, people were suing Cessna and sometimes winning, sometimes not. What Cessna argued is Congress should, for economic reasons, because of the economic crisis for general aviation aircraft, Congress should have a national law that provides that under no circumstances in any of the 50 states can anyone sue a product manufacturer of a general aviation aircraft more than 18 years from the date the aircraft was sold or the part thereof was sold. This is called a statute of repose. It's different from the statute of limitation. Statute of limitation runs from the date of the accident, effectively. The statute of repose is from the date the product was sold. 18 years. What Cessna is saying is if Congress will make sure that no one can sue in the United States more than 18 years after the product is sold, we'll get back in the business of making these things. And through Bob Dole, then senator in Kansas, and some other people, GARA was passed, and Cessna, true to its word, opened up a plant in Independence, Kansas, making piston lift aircraft again. That is a great example of how this works. The public policy issues, how it tipped way over on one side, and then how Congress, through essentially a tort reform. By the way, when Congress passed GARA, it trumped all 50 states' laws with respect to the statute of limitations on these things, and that is using the supremacy clause, sort of as a matter of crisis. Now, the modern causes of action available to somebody suing for product liability consist of three basic categories. First is breach of warranty, and note that I say contract, and that is true with respect to express warranties, which we'll talk about. There are also two implied warranties, and while they're called warranties, they are technically not contracts, as I will explain. They are statutory causes of action. In other words, the state legislature has created these potential causes of action for people who are injured by defective products. And then we had two torts: negligence, which we've already talked about, and strict liability, which is a new tort that we haven't talked about yet. In most product liability lawsuits today, you will find those three types of warranties, and sometimes four. Let me go ahead and tell you that the most common cause of action are the implied warranty of merchantability, which is really a statutory warranty, negligence, and strict liability. Sometimes you will find the other types of warranty as well. Now, let's go through the warranties. Express warranty is a promise or statement of a representation of fact. It's where a product seller either states something about the fact as to its quality, like, basically describing how good the product is, or much more commonly, it's something like this second bullet point: we will repair or replace defective parts for 1 year. And all of you know how these warranties go. When you buy any type of product today, there is some type of warranty, if it's costs very much, that is, like an electronics item, like a motorcycle and car and so on. Many of you are familiar with car warranties. It's like 3 years or 30,000 miles, whichever comes first. That's an express warranty. So an express warranty is usually in writing. It could be verbal. You could have a product seller actually verbally make a representation. But it is definitely express, as an express contract, it's express words. The scope of the warranty is described for you. When you buy a new car, you get a warranty from the product manufacturer, let's say Toyota. But you also have warranties for things like tires, batteries, and other things. And the reason you have those warranties is not because of Toyota directly. The tire manufacturer extends an express warranty to you through the warranty card, and it is those warranty cards, even though you don't have a direct contract with Toyota as such, Toyota extends that warranty to you through the warranty card. So that's how express warranties work. Couple words about extended warranties. An extended warranty is a type of express warranty as well. Sometimes I spend a lot of time on this, but I'm going to kind of simplify this. I've been very outspoken over the years about extended warranties. I see it as a risk management tool. If you buy a product that costs $75 and Best Buy or whoever asks if you want to buy an extended warranty, which is a warranty that extends the original 6 months or 1 year, whatever, on. My thought is, $75, you're only paying $75 for the product. Why would you spend another $10 for an extended warranty? It's your choice, but even if the product breaks after a year or two, it may be outmoded anyway. This is the view that some people have about cell phones. Why buy a warranty from Apple or whatever, the argument goes, when you're probably going to want to replace your phone in a couple years anyway. That's the point of this. For cars, it's a little different, of course. But let me tell you a quick story just to kind of summarize my take on this and just something to think about. Well, first of all, an extended warranty for cars. Understand that it really matters who is selling you the warranty. Sometimes it is the manufacturer. So Honda gives you 3 years, 30,000 miles, whatever. But then you can also buy an extended warranty that at the time you buy the car, it extends the warranty out another couple of years. You'll pay $1,500, $2,000, whatever it is. If the warranty comes from Honda, okay, Honda's a reputable company. The problem I've seen with these things is that quite a few of these extended warranties are sold by companies you've never heard of, and I mean this literally, that are based in the Bahamas or Bermuda. They're offshore. Good luck with trying to enforce that warranty. There's some real problems with these things, but here's my point. If these extended warranties were really necessary, that okay, maybe there's some argument for them. But car dealers, when they sell your car, they don't make a heck of a lot of money on the car sale itself, believe it or not. The margins are pretty thin. They make their money on service by trying to keep you happy so you keep bringing your car in for service, and on extended warranties, because an extended warranty is auto repair insurance, and it's sold as insurance, and they have to be licensed as insurance people to sell it, and it's almost pure profit. And that's fine, but be aware that's what it is, and this is why they push you so hard to buy one. So here's my story. The last new car we bought was a Honda. I bought many new cars, and I know the drill. At the very last minute, when you go in to do the paperwork, somebody comes in, one of the business people, and gives you the hardest sales job you've ever seen in your life to buy an extended warranty. I have literally had check in hand for the full price of a car in the past and got up to leave because the business person wouldn't get off the warranty thing. After the third or fourth time I said I don't want an extended warranty, I had to threaten to walk away and not buy the car. With the Honda, it wasn't quite that bad. And we got through the whole thing, and then sure enough, they sent us in to talk to one of the business people in the office who happened to be a former student of mine in Business Law 431, and a great guy, and he saw me and he said, he goes, please listen to me and give you my spiel about the express warranty. It's my job. I have to do it. And I said, I understand. And he said, I know you don't like these things very much, but please listen. I said, I will. So I was good-natured, and I listened. And I said, you have to have an insurance agent's license to sell these, don't you? And he said, yeah. And that's fine, whatever. And at one point, he got really excited and trying to convince me we needed this warranty. Got a little carried away. At one point, I said to him, now listen, for the last few days, the salesperson has been telling us that Honda has the best repair record of any company on the market, fantastic safety record, hardly ever needs to be fixed. You don't need a tune-up till 100,000 miles. And now you're telling me I need an extended warranty for $1,500 because this piece of crap's going to fall apart as soon as I leave the parking lot or whatever. I mean, just think about that for just a moment. So, at any rate, that's my spiel. Let's talk about implied warranties. Needless to say, we didn't buy the Honda extended warranty. There are two types of implied warranties, and here's the thing about implied. Implied means imposed by statute, not implied by the manufacturer. Indeed, manufacturers hate implied warranties, and they wish they didn't have to deal with them, but they do. And it's vague. You see, a lot of companies will give you like a 1-year warranty. Good example. One of my clients sold windows and drywall and things like that. They had sold and installed a whole bunch of windows a few years ago. And they gave their customer a 1-year express warranty. Will replace defective windows within 1 year. So this warranty doesn't apply only to people being injured. It also applies to just defective products and getting them repaired and replaced. And that's the express warranty. I'm sorry. So the express warranty typically is just to fix the product. We need the implied warranties, the argument goes, if the defective products hurt somebody. So my client called up one time and asked me if there was some catch here. He said, we sold these windows, we gave a 1-year warranty, and we're getting a lot of calls. These windows apparently are defective. We bought some defective windows from China, and we're getting a lot of calls. We keep telling people, you only have 1 year, the year is expired. And they keep complaining, are we missing something? I said, yeah, you're missing the implied warranty of merchantability, which is not limited to the 1-year warranty. It has nothing to do with an express warranty. It is imposed by law. It is a warranty that when somebody sells you a product, you should expect it to last for a reasonable period of time, to be fit for its ordinary purpose, to do what it's designed to do. Basically, the idea is if you buy something, and this includes used products, by the way, if something happens that is unreasonable, that is unusual for that product, that it breaks down too quickly, you might be able to get it fixed under the implied warranty of merchantability. And as we talk about some of the product liability cases in a little bit, most of them will have a cause of action for the implied warranty of merchantability. If you buy a lawnmower and it blows up the second time you use it and you're injured, it's not fit for its ordinary purpose. It didn't do what it was designed to do. Lawnmowers are not supposed to blow up the second time you use them. Therefore, that would be a breach of the implied warranty of merchantability. The merchantability warranty comes automatically with the product. Now, this warranty is very specific and only comes up in certain situations, and it applies when the merchant makes a representation or recommendation about the product for a very specific purpose. I'll just give you a quick example of it's when let's say a retailer is known to be an expert in that product, and you ask them to make a recommendation as to which particular product to buy for your needs. If they make a recommendation, you buy it, and it turns out their recommendation was wrong, that is, the thing they told you was wrong, this warranty would kick in. Probably the best example, and it's very simple, I read a case where a police department purchased bulletproof vests, and they were, I guess, told that this particular vest would stop certain kinds of bullets. They didn't, and they sued for the breach of implied warranty for fitness for purpose. One of the things that manufacturers try to do, because they don't like implied warranties, is to disclaim them. Disclaim them means to put something in the contract they had with you or in the warranty card that says we are not responsible for implied warranties. It is pretty common, next time you buy a product with a warranty, pull out the warranty card, you will probably see something that goes like this. We will repair or replace defective parts for 1 year. That's the express warranty. Next sentence. All implied warranties, comma, including but not limited to the all caps implied warranty of merchantability, comma, are hereby disclaimed. Let me stop for a moment. Kansas law, under the Kansas Consumer Protection Act, provides that merchants can't disclaim implied warranties for consumers, which means individual purchasers, consumer transactions. If they attempt to do so, it's $10,000 penalty per customer. So KCPA, remember this, 10 grand per customer. So you're thinking, well, why did they put this disclaimer in these warranty cards? Because the next phrase that I haven't given you yet, after saying we hereby disclaim all implied warranties, blah, 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 then says, except in those states that do not permit the disclaiming of implied warranties. And by doing that, the courts generally feel that's okay because they're selling to 50 states and it gets complicated. Remember, however, that even in Kansas, there is no prohibition for a merchant disclaiming implied warranties in a commercial transaction, which means selling to businesses. Okay. They cannot do it for consumers. They can do it for a business transaction. And I guess I need to make sure you understand the word merchant. And the UCC, which, by the way, the implied warranties I talked about come from Article 2 of the Uniform Commercial Code. The word merchant means anyone in the business of selling that type of product. Here's a case from Kansas that illustrates how these various warranties work. We'll run through it because the facts are instructive. Brenda apparently had quite a thing for very, very super white teeth. She had had many different veneers, which is basically capped teeth, little things you put over your teeth, and she wanted super white teeth. She was not happy with the one she had, so she's looking around for replacements. She saw in a brochure from Denmat that said our veneers last 16 years and no discoloration, so she was interested. And she found out from Denmat that they had an authorized dentist, that is somebody who sold Denmat as a dealer, a Dr. Gill in Wellington. So she made an appointment, went to Dr. Gill, and then he made some verbal statements as a representative of Denmat that basically said, yeah, it's true, these things don't discolor, they're great. And then he told her, I, Dr. Gill, will give you a 5-year warranty. If you don't like these things, you can get new ones for 5 years. She paid about $10,000 and immediately was not happy with the color. They weren't white enough. So then she went to her dentist, her own dentist, had them taken off, and then got new veneers for $4,500. And as you can see, she sued Denmat and Dr. Gill for breach of express and implied warranties. The court held that Dr. Gill's statement that they would not discolor was an express warranty. So there's an express warranty from both Denmat, the manufacturer, and the brochure, and also Dr. Gill's verbal statement. There was an implied warranty of merchantability that the goods, in this case the veneers, would satisfy basic standards. What would you expect the veneers to do? How long should they last, etc. And you can see this quote, the implied warranty of merchantability depends on the circumstances, the reasonable expectations of the ordinary user. So it's not so much what Brenda would expect, because apparently she was a very picky person and almost impossible to please. I mean, it's pretty clear from the case. It's from the ordinary purchaser standpoint. What would they expect based on general consumer expectations rather than subjective beliefs of the buyer? Now, on the implied warranty of fitness for purpose, the court said if the seller has reason to know of a particular purpose for which the goods are required and understands that the buyer is relying on the seller's skill or judgment to select them, then there will be a applied warranty for fitness for purpose. So that applied here because she was relying on Dr. Gill and asking him basically if this product would do what she wanted. So that's how it works. Okay, I guess I have this slide in there twice. I'm sorry for that. Now we'll move to strict liability. Now again, remember negligence is a common cause of action, but we've already talked about negligence and the elements. Strict liability is a relatively new tort. It began in California and then moved out from there. And so that's important because California always, or not always, often sets the tone for new causes of action. But most, I think all states have it today, certainly Kansas does. No privity of contract is required. Okay, this is important. Every single merchant can be sued for strict liability because it's not fault-based. If they sold the product at all to anyone and it ends up hurting somebody, they can be found liable. Strict liability means it is a no-fault law. We're going to go through the elements. I'm going to give you examples, case examples of some of these elements. You need to know all 4 elements. First, you can only sue somebody for strict liability if they are a merchant. You can't sue somebody who sells something at a garage sale or an estate sale. Second, the plaintiff must prove the product is defective. Well, that's true of every product liability case. The difference is the plaintiff does not need to prove how specifically it is defective. I'll give you an example of that in a moment. Number 3, the plaintiff must prove that the product is in substantially the same condition at the time of the accident as it was when the plaintiff purchased the product. And I'll give you an example of that. And then 4th, product must be unreasonably dangerous. Now, this is an important one. What does that mean? You remember back 100 years ago, they used the phrase inherently dangerous. Well, now they're talking about unreasonably dangerous. So let me pose this question to you. Is bread unreasonably dangerous? Now think about it. Normally not. If you buy a loaf of Wonder Bread at the grocery store, not terribly dangerous. If you hit somebody over the head with it, if you dropped a loaf of bread in your foot, I don't think you'd have any damage. But what if the bread had some, microorganism in it that caused somebody to be very sick? This is a real case from Kansas. A guy sued a grocery store and a bakery because he claimed that he was eating a sandwich and he bit into a sewing needle and it pricked the inside of his mouth. And that during that night, he woke up in excruciating pain, went to the hospital, and had to have surgery because he had swallowed a pin, a straight pin, pins and needles. He won. The grocery store and the bakery were merchants. Was the bread defective? If it has a needle and a pin inside it, it is, because it's not designed to have that. Number 3, was the bread in the same condition when he chomped on it as when he bought it? Now this one's interesting. Where did the needle and pin come from? Was it in the bakery? Did somebody put it in the bakery? Did some sick person in the grocery store stick it through the wrapper? If so, then the bakery can be strictly liable even though the bakery's not at fault. The point is, if in fact the needle and pin were in the bread when it left the store, then yeah, it's in substantially the same condition. Now, in the real case I'm talking about, the guy was a heavyweight boxer who lived in Kansas. He sued and he won. So apparently he was able to convince the jury that it left the bakery and or the grocery store in that condition. Number 4, is the bread unreasonably dangerous? Well, if it has a needle and a pin in it, yes. Number 2 and number 4 are often linked. They often go hand in hand. So, when we're talking about unreasonably dangerous, is a knife unreasonably dangerous? No. Actually, a knife is reasonably dangerous. You want it to be sharp. It's only unreasonably dangerous if it breaks when you're cutting something that you would expect it to cut. If you're slicing a tomato and the knife breaks in 2, that's probably an unreasonably dangerous knife, and so forth. Now we're going to run through a little more specifically how you prove defect. A defect can be proved in a number of different ways. It could be that the design is defective. Now, this happens quite a bit with cars and products like that. It could be that the defect is not in the design is okay, but that there was a human error in the manufacturing process. Now, I will make a point that design defect is scarier in many ways because it's systematic, but there could be a manufacturing defect. And then there's also something called duty to warn, and I'll give you some examples. A duty to warn means that the product itself is okay, but there are some side effects or there's some things you need to know about. And if they fail to give you those adequate warnings, that in and of itself can be a defect. So let's run through some case examples. These are real cases. A guy bought a Samsung microwave in New Hampshire from a local appliance dealer. Had it about 6 months. Came home from work one day and the microwave was on fire, as was his kitchen. And no one was injured, but it did quite a bit of damage to his house. And he sued both the dealer and Samsung for both negligence and strict liability, and I think the implied warranty of merchantability as well. So, how does it work? For negligence, remember, you must prove breach of the duty of care, which means fault, which means he would have to prove to the jury's satisfaction specifically what was defective about the microwave. Was it a wiring design problem? Was it a human error on the manufacturing assembly line where one of the workers got the wires crossed? What was it? If you can't prove the specific defect, the but for, what did we do wrong? We lose on negligence. He lost on negligence. He couldn't prove how. The experts testified that the fire definitely originated on the backside of the microwave, but that because the wires in the microwave were burned so badly, they could not tell what was wrong with the microwave. So he lost on negligence. He won on strict liability. He proved that it was defective. How? Well, a microwave is not supposed to catch on fire while you're at work. That's not part of the design function. Is it unreasonably dangerous? Yeah, if it catches on fire while you're at work. Was it in the same condition at the time of the fire as when you purchased it? Now, this one's a little trickier. How would you prove to a jury that your microwave is in the same condition as when you bought it? Well, here's how I would do it if I were your lawyer. Put you on the witness stand and say, did you ever take this microwave apart and try to fix it? Did you ever do anything except just use it? And you would say, look, all I know is I'm not a very good cook, and so I just put the baked potato in. I hit the button for potato, and that's it. I never did anything. I mean, it's not believable that people take apart microwaves. Now, how would the manufacturers cross-examine you on that point? Well, they'd ask you, did you follow the instructions for the microwave? Did you put in things you weren't supposed to, like styrofoam? Did you let grease get built? I mean, those kinds of questions. So that's how it works. It's a good case to remember for a test, though, or even a quiz, because if you won on strict liability, you don't have to prove how it's defective. Now, I joke about this one, figurative spontaneous combustion. A man was eating a box of hot tamales in his recliner watching TV, got about halfway through the box, popped one in his mouth, and he said later it felt like his mouth was on fire. That is a figure of speech. He didn't mean that literally, of course. And he went to the emergency room, I guess, and he did indeed have a chemical burn inside his mouth. He sued Just Born Inc., the manufacturer of hot tamales. These things are kind of misnomers. They are called tamales, they're not tamales, and they're called cinnamon, but they're not cinnamon. There's no cinnamon in these things. Turns out it's a chemical that tastes like cinnamon. His allegation was that the company had put in too much of the cinnamon flavoring. Well, here's his problem. First of all, he had eaten the evidence. Secondly, by his own admission, all of the other hot tamales in the box up to that point were fine. He testified that he ate about a box of hot tamales a week. Never had a problem before. Now, they did have the uneaten portion of the box. They tested them, and they had the batch number, so they tested off other hot tamales from that batch. No problem. There was no excessive chemical flavoring in any of the other boxes. So, is it logical that one lonely hot tamale could have too much chemical and the others not? And the court said, no, that's not logical. We're dealing in probabilities here. He lost. He could not prove defect. In these cases, they do a lot of testing, a lot of replicating to see, and had they found other hot tamales that had too much chemical, he's good as gold. He would win. But you got to prove defect, and it's got to be by probability. Now, this case I've covered for quite a few years, and I kind of simplified it by showing pictures rather than all the facts. This is Rolf. Rolf was a Scottish big game hunter. He would take people on safaris to Africa. That's been kind of controversial recently. This happened several years ago. Rolf himself had shot and killed something like 100 lions in his illustrious career. And I have a very difficult time saying this with either a straight face or without a little bit of a laugh. Rolfe was an advocate and a well-known advocate for ethical hunting. And what happened was he was taking a client out on a safari, and his client raised his rifle to shoot a lion. He shot the lion in the paw. The lion was not amused. The lion was not fatally injured either, and it ran off. Rolfe later testified in court that being the ethical hunter that he is, he didn't want the animal to suffer, so he tracked the animal for hours to put it out of its misery. He found the animal, and when he saw the lion saw him, the lion apparently said, "You are the guy who is leading the safari that idiot who can't shoot shot me." So the lion turned and charged Rolfe. Rolfe stood there calmly, took steady aim, testifying later that he had shot several lions in his career that were charging him, and when he did so, he always shot in the same location, which is the clavicle, the collarbone. He shot the lion in that exact spot, as always, but unlike the previous occasions where the lions fell down dead, this one didn't. It kept coming, and it caught up to Rolfe and chewed on him. He was mauled by the lion. He lived. And who do you sue? Well, you can't sue the lion. The lion did die shortly thereafter. So who do you sue? Well, you sue the bullet manufacturer, of course, because rifle bullets, are designed to expand inside, roll, tumble, whatever, as this picture is attempting to depict. In other words, the entry wound, small, round, exit wound is supposed to be big, gaping hole. When they found this lion after it died, the exit wound was the same size as the entry wound, which was kind of mysterious. Rolfe concluded, therefore, it must be a defective bullet. Went to trial in Minnesota, of all places, and the defendant was federal cartridge, and they checked the other bullets in the box, his unused box of bullets. They checked the batches, they checked all the other bullets. They even they wanted to simulate shooting a lion. And the court actually said in the case, it's not practical or a good idea to replicate the accident by shooting at a real charging lion. So they took a box, put foam in it, or pig belly or whatever, put elk skin around it, and shot the other bullets into the box, and indeed the other bullets all expanded. Just like the previous case, Rolfe's argument was the bullet was defective, but none of the other bullets were defective. The court said that's not probable, that only one bullet would do this. There's no explanation, you lose. For years I covered this case and later wondered whatever happened to good old Rolfe. Turns out after this case, in the early 2000s, he was gored by a water buffalo. I guess he decided to hang it up at that point and died a few years ago of natural causes. Okay, this case is not in any way funny. It is very sad. Ashland, Kansas, high school football game. JR, because he was a minor, in the case when you read it, it just says JR, fractured his neck making a tackle, and as a result of this, he was quadriplegic. He sued Riddell, the manufacturer of the helmet. Riddell had sold the helmets to the high school. The coaches had shopped around for helmets and chosen this one. During discovery, the plaintiff's attorney learned that Riddell itself knew that it had other helmets that it sold that were 20 to 50% safer for this type of injury. And they also knew that simply adding 1/8 inch padding to the helmet significantly reduced the risk of this type of injury. The price differential between the two helmets was only something like, $12, $15 a helmet. The coaches testified they were never told about this safer helmet. The jury came back. We talked about the quadriplegic case in torts. This is 20 years ago. A Wichita jury came back with a $12 million verdict for a 17-year-old quadriplegic. Basically, what the jury found is because of what Riddell knew, it should have taken its crappy helmet off the market completely and just gone with a safer helmet. Or, at the very least, it should have disclosed to the coaches the statistics it had about the two helmets and then let the coaches decide. Because it withheld that information, the jury went nuts. Now look at the comparative negligence. Riddell, 63%, which means that you take 37% of the $12 million and JR didn't get it. That's how it works. And of course, then there's the cap for the non-economic. Now, JR was tagged with 21%. That had to do with the fact that he had been trained by his coaches on how to make a proper low tackle around the ankles and knees. And he didn't do that. He didn't put his head in the right position. So that knocked off 21%. And for years I covered this and I said, okay, what's going on with JR's parents? He didn't sue his parents. Riddell asked them to be put on the verdict form, but the case didn't say why. The parents were assessed 16% negligent. And so for years I'd always say, what the heck did the parents do? And in class we'd speculate about it. And one year, years ago, a student on the front row raised her hand and said, that's my cousin. And I'm like, oh my God, this is the problem, covering Kansas cases. And after class she came up and I said, well, I'm sorry about this. She goes, oh, no, that's okay. I mean, I knew about the case, but I have no idea what this thing about my aunt and uncle, the 16%. I never heard about that. And so she volunteered to go find out. She reported back to me that she talked to her aunt and uncle. And I had been imagining all kinds of things, like JR had a prior health issue and his parents knew it but didn't disclose it to the coaches. It was because they had signed the release form for him to play football. So you never know what juries are going to do. Duty to warn. There are a whole lot of cases involving duty to warn where the product itself is fine, but again, there are certain risks associated with using them. Well, today when you buy any product, about half the little booklet inside the box is all the safety stuff. Like, be sure to plug in the cord. Be sure to not plug in the cord when, whatever. And they have to do that because there are a lot of people that aren't terribly clever, and also because it helps avoid these kinds of lawsuits. I'm going to give you two examples of duty to warn. This one is a case I worked on long ago. I was a brand new lawyer, and the facts were a woman in a small town. She was kind of not sophisticated, had never purchased a 2-liter bottle of soda before, and she took it home. And at that time, they were using metal caps. That's how long ago this was, instead of plastic. And she's looking at this metal cap, and she couldn't figure out how to get it off. Rather than just twist it off and break that little metal seal, today plastic. And so she testified later in court that not knowing how to do it, she thought maybe something had broken off, like a little tab or something. So she grabbed a pair of pliers and started yanking on it. Unfortunately, she was pointing the 2-liter bottle of 7-Up at her face at the time. And yes, it exploded. The cap flew off and hit her in the eye, and she lost an eye. Now, she sued everybody in the chain of production. Safeway, the grocery store, 7-Up, the manufacturer of the soda, and Alcoa, the maker of the metal caps, the aluminum company that was the component manufacturer. Her lawyer argued at trial. I was a research attorney on this. I was not one of the trial attorneys. I was new, but I watched quite a bit of it. And her attorney argued that the problem here was that 7-Up and Alcoa had not put enough warnings on the bottle cap, written warnings, that would help. Now remember, for negligence, it's the but-for test. But for our negligence, she wouldn't be injured. I mean, what is the defect, in other words? Now, what the attorney argued to the jury is we should have put stuff on there about contents under pressure, point away from the face when opening. He didn't say we should have put a warning on there, don't use pliers. I'm surprised he didn't argue that one. Now, it goes to the jury, and the jury comes back with, and this is 28 years ago, $400,000. I was appalled. How is this possible? And what was really interesting was during cross-examination, my law partner, Mark, asked the woman, he said during cross, you have to be careful when you're cross-examining somebody like that. And again, keep in mind, the three defendants are gigantic corporations and all have insurance and everything else. And so this is the deep pocket theory at work. And he said to her, ma'am, now your theory in this case is the reason you were injured is because we didn't put adequate warnings on the bottle cap. Is that correct? Yes. Did you read what we did put on the bottle cap before you used the pliers? And she said, no, I didn't. In other words, we had put on there twist off and some other stuff. So he just said, thank you. He didn't make a big deal about it. And then closing argument, he said, ladies and gentlemen of the jury, her argument that we should put other stuff in writing on the warnings on the bottle cap wouldn't have helped her. There is no proximate cause here. The jury didn't buy it. And the reason was the jury looked around, saw three very wealthy corporations and a woman who was poor and had an eye put out. And that sounds cynical, maybe, but that's how it works. Sometimes you never know what's going to happen. And speaking of never know what's going to happen, in this case, the woman whose lap was burned by the burning coffee was given a jury award of nearly $3 million, about 2.9, and everybody's made fun of her ever since. But there's a more serious side of this. It's now a movie. She was 79. Her grandson had a bump. She dumped the coffee in her lap. She jumped out of the car. They were going through a drive-thru. She jumped out of the car quickly, but by the time she got to the bathroom, it was too late. She was burned badly, partly because she's 79 and her skin is not as good a shape as a younger person, and partly because she had sweats on, and sweats absorb the coffee. Had that been these swishies or something like even your bare legs, you could have brushed it off. And at any rate, everybody makes fun of the case because coffee is hot, did it warm. But the real issue in the case had to do with the machine. McDonald's coffee, the machine it uses, makes coffee 20 degrees hotter than competitors. It's true. McDonald's admitted it. They said the reason is because coffee tastes better when it's really hot, which is true. They had been asked by Shriners Burn Hospital over the years to reduce the temperature of the coffee. Who's Shriners Burn Hospital? Oh, just the best charity in the United States for helping children who are burned, and they provide free medical care. And McDonald's had refused to reduce the temperature. So somebody got up on the witness stand from Shriners and we've been asking McDonald's for years to reduce the temperature, and they just won't do it. I think that's what got the jury mad. The woman had actually at one point offered to settle for $20,000. I mean, the point is, there's a lot more to this case. Then the judge knocked the verdict down substantially to less than $500,000, and then they settled, probably for about $250,000 or $300,000. Would that work in Kansas? And I'm talking now about the duty to warn part. Well, in this case, it's the exact same issue. Actually, there was two issues. One was the temperature of the coffee involving the machine, and the federal judge in Wichita, somebody I know, and he listened to the evidence. The jury came back with a $75,000 verdict. There was an 11-year-old boy. His mother had a bump, dumped the hot chocolate in his lap. And you can see in Kansas jury is a little tougher on the mother, 50% for being a reckless driver, I guess. And the boy, 20% for being a reckless holder of hot chocolate in his lap. But the judge listened to the evidence, and at the end of that trial, after the jury came back, the verdict said, no, there's no way these guys are liable. Now that I've heard the evidence, it is and this is the part that's important in the law. In Kansas, you do not have to warn of a known danger. Coffee is hot. Hot chocolate is hot. In fact, it's in the name, hot chocolate. Knives are sharp, etc. Beer, alcohol can be addictive. All of these cases are out there somewhere. So you don't have to warn of something that the average person would know is dangerous. Now, for a long time in class, for this case, I would have a list of facts that I would bring up point by point in the bullet points just for dramatic effect. I think I'm just going to do it verbally here. It's a Missouri case. An elderly couple had a couple acres in Missouri, and they had a riding lawnmower, and they had a little dog, and great-grandpa had constructed this little doggy box on the front of the mower so that the little dog could ride around. It was open, there was no seatbelt, open on one side. And people would always groan at this point because we were talking about dogs. And then I added the next bullet point, which is one day when great-grandma was mowing her yard and her 18-month-old great-granddaughter was riding in the doggy box, and then there's a big groan. What happened was Grandma hit a root, the tree, the girl was thrown out, and Grandma ran over her foot. It could have been much worse, but the little girl had a very severely injured foot, and her parents sued Sears, where the mower was purchased, and Roper, the manufacturer of the mower. For what? The cause of the accident was a doggy box that Grandpa put on the mower. Incredibly, this case went all the way to jury trial, and the jury just slapped Sears and Roper silly. You'll see. $1.5 million in damages, assessed 60% of the fault against Sears and Roper, and 40% against great-grandma for being a reckless driver. This is another case where the trial judge granted a J&OB motion, which means reversed the verdict, said no way. There's no way that Sears and Roper can be liable. The jury, in other words, the jury felt sorry for the little girl. And then the family appealed it to the Missouri Court of Appeals, who said, look, the cause of the accident was you put a box on there. It wasn't part of the design. This was not designed to be a motorized baby buggy. Therefore, it was not in the same condition. Justice was done, but it took a long time and a lot of money. But at least with appeals, you had a shot. The last two slides deal with two very specific legal doctrines. The first is market share liability. Here's the deal. Sometimes you have a product that's defective, and it's made by several different manufacturers. And we don't discover until many years later that the product is defective, and by then, no individual really knows for sure who the manufacturer was, and there are lots of plaintiffs and several defendants, and trying to sort out the damages is impossible. And I mean by an individual basis. Examples of drug company. There have been several cases involving a type of drug that was defective, and later people didn't really know who the manufacturer of the drug was, the prescription. So it only works in class action cases. Here's the idea. If we have a class action lawsuit, which means lots and lots of plaintiffs, and we have, let's say, 3 companies that were manufacturers of the product, then we simply look at the market share relative of each of the 3 companies during the time in question, and we assess them the damages based on that percentage. So if company A had a 40% market share, then we'll just tag them with 40% of the damages. It's a sensible and simple way and a fair way to deal with the problem. The last topic is, I'm going to use the term crashworthiness. Okay, so remember that. It is also known as second injury, and I'll explain why. And it is not a cause of action. Remember that. It is not a cause of action. It is a legal doctrine. And what that means is that it is a legal doctrine that is used in some product cases against manufacturers as a theory to help the plaintiff win a negligence or strict liability case. Okay. It involves safety products. The idea is that manufacturers of products should be proactive and think about ways they can reasonably, they don't have to go to extraordinary lengths, but reasonably make the product safer so that if someone is in an accident, the injuries will be minimized to the extent possible. One of the more interesting cases I worked on involved, by the way, forget the motorcycle, I just tried to find a picture of the river. So the motorcycle just happened to be sitting there. The case involved a car that was driving down the road at a high rate of speed with 4 19-year-old teenagers inside. And it was a beautiful warm day, and they had the windows down. And the driver was driving so fast that he lost control of the vehicle that looked like this, and the car went airborne. there was an eyewitness, believe it or not, across the road who saw the car airborne, rolling and tumbling down the highway. The car flipped into the river. I'm going to go back. Right side up, in about 2 or 3 feet of water. The driver, again, window down, did not have his seatbelt on. He flew out the window, his window, face down the river. He was saved by 2 guys in the back. Somehow got out of the car. They were only injured, broken ankle, cuts and bruises. And the 19-year-old girl in the front passenger seat was the girlfriend of the driver. She flew out her window, hit some rocks on the side of the road, and was killed instantly. Her family sued the boyfriend, obviously because he was speeding, and General Motors that made the Chevrolet Camaro. General Motors was sued. The allegation was defective seatbelt. The family's argument was that while the driver caused the first injury, in other words, speeding caused the car to flip, she would have been injured. Because the seatbelt didn't work, the argument was her injuries were worse, in her case, death. That's the second injury part. In these cases, when you have multiple defendants, the strategy is to try to obviously win the case. We represented General Motors, and we wanted the jury to find that the driver was at fault, but the seatbelt was not defective, so we would have 0% negligence. But our backup strategy is that if we are tagged with negligence, that it be as small a number as possible, which is to say I need to get the driver's negligence up as much as possible. And I was doing my investigation. I actually found the car. Nobody even knew where the car was. We found the car. It was behind a station in a small town. It had been cannibalized, which means pretty much everything stripped out of it, incredibly, except the seatbelts, which were still bolted. We had the experts on both sides go in a room, open up seatbelt. It was fine. Neither side could find anything wrong with the seatbelt. But the family's argument was that the seatbelt failed. Here were the 2 pieces of evidence. The autopsy said that she had a contusion on her chest consistent with the size and configuration of a shoulder harness. Now, our theory was that the scrape on her chest came from flying out the window and hitting the car. And I'd worked on several cases, and I think that's very possible. The other evidence that we had, though, was that I was able to track down an eyewitness, not to the accident, but to the car passing a half hour before the accident at a high rate of speed. I called him and said, "Sir, how fast was the driver going?" This is 2 years later now. And he eventually said 100 miles an hour. He was passed at 100 miles an hour in a 55-mile zone on a twisting mountain highway. And as he was getting ready off the phone, of course, I'm excited thinking, oh man, I've got a great evidence. The jury's going to be so mad at this driver. And I said, anything else, sir, that I haven't asked you that might be helpful to me in terms of understanding the case? He said, well, when they passed me, the girl was sitting outside the car. I said, excuse me? He said, yeah, she had her rear end on the car door, her hands were on the roof of the car, and as they passed me, she waved and smiled. He said, it was so tragic when I found the accident, and a half hour later, she was dead. Now, I pose this question. Was she prudent enough to get back into the car after sitting outside the car at 100 miles an hour and put on her seatbelt? In those days, seatbelts weren't required. Or did she not put her seatbelt on? It was a half hour later. This is why cases settle. We had some good evidence, but remember the deep pocket theory. And General Motors was concerned about what a jury might do, so we settled. But I will say the settlement value was helped, from our point of view, by the fact that we had this evidence. And that concludes product liability.